oversight hearing, Ray committed to protecting whistleblowers that have approached my office about wrongdoing at the department and the FBI. Do you commit to me, this committee, and the Senate as a whole, that any retaliatory conduct against whistleblowers will be disciplined?
I do, Senator, and you know well, more than any other member of this committee, that I've been a staunch supporter of whistleblowers and of the False Claims Act during the entire period of my role as a judge as well.
I'm going to set up a hypothetical fact pattern for you and ask you to tell me how you would handle it. The Justice Department and FBI receive information from over a dozen sources. That's the first one. Second, those sources provide similar information about potential criminal conduct relating to a single individual. And third, that information was shared with the Department and FBI over a period of years. According to department policy and procedures, what steps would the department take to determine the truth and accuracy of the information provided by those sources?
I'm sorry, these are whistleblowers, so they're internal sources, is that what you're saying? I'm not sure.
Doesn't matter where that comes from, just the fact that I want to know you got that information. How would you go about handling it?
Yeah, so reports of wrongdoing are normally reported to whatever the appropriate department component is. It might be U.S. Attorney's offices in the district in which it allegedly took place. It might be directly to FBI components and to FBI task forces. In cases involving whistleblowers, of course, there are specific provisions for making complaints to the Inspector General's office or the Office of Professional Responsibility or the Inspections Division of the FBI.
Recent lawfully protected whistleblower disclosures to my office indicate that the Justice Department and the FBI had at one time over a dozen sources that provided potentially criminal information relating to Hunter Biden. The alleged volume and similarity of the information would demand that the Justice Department investigate the truth and accuracy of the information. Accordingly, what steps has the Justice Department taken to determine the truth and accuracy of information provided? Congress and the American people, I think, have a right to know.
So as the committee well knows from my confirmation hearing, I promised to leave the matter of Hunter Biden in the hands of the U.S. Attorney for the District of Delaware, who was appointed in the previous administration. So any information like that should have gone, or should have gone to that U.S. Attorney's offices and the FBI squad that's working with him. I have pledged not to interfere with that investigation, and I have carried through on my pledge.
In April 2022, you testified to Senator Hagerty that the Hunter Biden investigation was insulated from political interference because it was assigned to, as you just now told me, to the Delaware Attorney's Office. However, that could be misleading because without special counsel authority, he could need permission of another U.S. attorney in certain circumstances to bring charges outside the District of Delaware. I'd like clarification from you with respect to these concerns.
The U.S. Attorney in Delaware has been advised that he has full authority to make those kind of referrals that you're talking about, or to bring cases in other jurisdictions if he feels it's necessary. And I will assure that if he does, he will be able to do that.
Does the Delaware U.S. Attorney lack independent charging authority over certain criminal allegations against the president's son outside of the District of Delaware?
He would have to bring, if it's in another district, he would have to bring the case in another district. But as I said, I have promised to ensure that he's able to carry out his investigation and that he be able to run it. And if he needs to bring it in another jurisdiction, he will have full authority to do that.
If you provided the Delaware U.S. Attorney with special counsel authority, isn't it true that he wouldn't need permission of another U.S. Attorney to bring charges?
It's a kind of a complicated question. If under the regulations, that kind of act, he would have to bring to me to the Attorney General under the regulations. Those kind of charging decisions would have to be brought. I would then have to authorize it and permit it to be brought in another jurisdiction. And that is exactly what I promised to do here already. That if he needs to bring a case in another jurisdiction, he will have my full authority to do that.
Has the Delaware U.S. Attorney sought permission from permission of another U.S. Attorney's office, such as in the District of Columbia or in California, to bring charges? If so, was it denied?
So I don't know the answer to that. I do, and I don't want to get into the internal elements of decision-making by the U.S. Attorney, but he has been advised that he is not to be denied anything that he needs, and if that were to happen, it should ascend through the department's ranks, and I have not heard anything from that office to suggest that they are not able to do everything that the U.S. Attorney wants to do.
Well, let me give you my view. If Weiss, the U.S. Attorney there in Delaware, must seek permission from a Biden appointed U.S. Attorney to bring charges, then the Hunter Biden criminal investigation isn't insulated from political interference, as you've publicly proclaimed. If the Justice Department received information that foreign persons had evidence of improper or unlawful financial payment paid to elected officials or other politically exposed persons, and those payments may have influenced policy decisions, would that pose a national security concern and demand a full investigation? And when Ray was here, he seemed to answer that question that it was a national security concern. I want your opinion.
In the way that if I follow the question exactly right, if it's an agent of a foreign government asking someone and paying someone to do things to support that foreign government in secret, yes, I definitely think that would be a national security problem.
Okay, my last question is to whistleblowers have confidentially asserted that the DOJ's Public Integrity Unit, I think I'm going to leave that question for another round. Thank you, Mr.
Thank you, Senator.
Thanks, Senator Grassley. Senator Klobuchar.
Thank you very much, Attorney General Garland, for being here.
For attending. In your opening statement, you said that you work to uphold civil rights. Is the Sixth Amendment one of those in the Bill of Rights?
The Sixth Amendment is one.
It is, great.
Certainly a civil right.
And you work to uphold civil rights for all Americans, is that correct?
Yes, that's correct.
All right. When the Sixth Amendment of the Constitution says the accused shall enjoy the right to a speedy and public trial by an impartial jury, what kind of a time frame does a speedy trial mean?
Well, there's two different ones. So there's the Speedy Trial Act.
That's correct.
I used to be able to tell you exactly how long it took, but I believe at least the first part I remember is 30 days from the complaint.
That's correct.
I think it's 120 days after that, and then there are exceptions for different motions for speedy trial.
Okay, I believe it says 70 days from the filing of charges of the defendant's appearance
It's been a
before the
long time
judicial
since I
officer.
actually appeared in magistrate's court to make that argument.
Okay, great. I'm glad you are well aware of that. Mark Houck was arrested September 23rd, 2022, and found not guilty on January 30th, 2023. The jury deliberated about an hour. DOJ accused Houck of twice assaulting the volunteer in front of a Planned Parenthood clinic and charged him with 2 counts of violating the FACE Act, freedom of access to clinic entrances. The arrest to the trial took just over 4 months. Would you consider that a speedy trial?
Yes.
All right, so would I. Last week, I visited the D.C. Department of Corrections and met with some of the 20 prisoners who were arrested in connection to the events at the Capitol on January the 6th. According to a Just Security article that came out on March the 20th, 11 of the 20 have not accepted a plea deal, nor have they even been brought to trial. Today is March the 29th, 2023. Attorney General Garland, is it correct that since their arrest, some of these individuals have been waiting approximately 2 years for their trial?
Look, I don't know the specifics of individual cases. The beauty of the Sixth Amendment is that each of those people is entitled to a lawyer, has a lawyer who can make a speedy trial argument in the court. Oftentimes, lawyers ask for more time. Oftentimes, they ask for exceptions for discovery. There was an enormous amount of discovery in those cases, but I don't know anything about particular cases.
Does waiting 2 years for a trial meet the speedy trial clause of the Sixth Amendment?
It can if the exceptions to the Speedy Trial Act are met. Those are the responsibility of the lawyers for those defendants to bring to the
Well, I would like you to look into that, because to me, I don't think waiting 2 years for your trial complies with the Sixth Amendment of the Constitution.
This is an argument to be made before the judge. The judge has the authority to dismiss a case for a violation of the Speedy Trial
You're
Act.
absolutely correct. A judge does have that authority. You know, like you said in your opening statement, you work to uphold the civil rights of all Americans. I think in this case, their civil rights are being violated, and I would appreciate you looking into that.
Thank you, Mr. Chairman. I'm listened with interest to the comments of the gentleman from Pennsylvania. I'm glad that he got a response, the minority got a response to their letter. I also sit on judiciary, and my chairman, Mr. Jodan, has asked me to ask you about a letter he sent back in January, asking you to appear before his committee. He has not gotten a response to that letter, and so I'd ask you, can I get a commitment from you to respond to him in the immediate future with several dates that would be, during which you would be available to appear before the Judiciary Committee?
Of course, I'm going to appear before the House Judiciary Committee. I understand there are discussions about scheduling that have been going on. I don't think there's any problem in that respect.
There's been no response to the letter, so I think there's some question about whether you would be willing to appear. So getting your commitment to appear is helpful, and I thank you for that.
More than willing.
Senator Lee.
Thank you, Mr. Chairman. Thank you, Deputy Monaco, for being here, and thanks for your service. In early March, we had Attorney General Garland before this committee, and I asked him a series of questions about 18 U.S.C. Section 1507, and specifically why no arrests have been made at the homes of Supreme Court justices in violation of that statute, which prohibits people from protesting or demonstrating outside the home of a Supreme Court justice or a judge or a juror or other officer of the court with intent to influence any court proceeding. His answer was succinct, but amounted to the effect that the marshals are on the ground, and the marshals have full authority to arrest under any federal statute, including Section 1507. About 3 weeks later, my friend and colleague from Alabama, Senator Katie Britt, before another committee, asked Attorney General Garland about a slide deck that she had discovered that was being used to train the U.S. Marshals who were performing their protective detail duty at the homes of Supreme Court justices. These slides seemed to contradict what Attorney General Garland had told me 3 weeks earlier. They contradicted in several respects. First of all, the slide number 4 says that in order to make an arrest there, they really need to be looking at something that demonstrates, quote, the intent of influencing any judge language, thus logically goes to criminal threats and intimidation, not First Amendment protest activities. Now, I personally, as I've poured through that statute, I don't see that as an element of the offense. It's not an element of the offense. There's nothing in there that requires it to have this separate, non-specified element within 1507 about the intent being something amounting to criminal threats and intimidation. That's not in there. Just as troubling, maybe even more so, is slide number 5, cited by Senator Britt at that same hearing, where it says that, quote, any contemplated U.S. Marshal Service enforcement action under 1507 should be coordinated in advance with the appropriate U.S. Attorney's Office. And as if that were not enough to discourage the marshals from making arrests under Section 1507 in this circumstance, it goes on to say that it is counterproductive to make probable cause arrests on cases that the U.S. Attorney's Office will not charge and prosecute. So I've been wondering, how exactly is it considered to be the full authority to arrest people under Section 1507, as the Attorney General has described, if you have to get pre-clearance first to do it, and if you're adding an additional element, one not found in the United States Code?
Well, Senator, I know the Attorney General has spoken quite directly to this about the direction that he has given and has repeatedly given to the Marshal Service, and the Marshal Service Director.
When he was asked about these slides, by the way, he was not aware of them. Were you aware of them? Were you aware of them before they were given to the Marshal Service to train marshals on how to protect the homes of Supreme Court justices?
No, Senator, but I also know that the Marshal Service Director has been very clear that he will regularly review the training provided to the Deputy U.S. Marshals, who continue to this day to provide 24/7 protection for the justices, their homes, their property, at the unprecedented direction of Attorney General Garland last year. This has never happened before in the history of the department.
I understand that, but I'm asking about the enforcement of Section 1507. Now, you're the Deputy Attorney General. Under the organizational chart of the Department of Justice, you have supervisory authority, oversight over the U.S. Marshal Service. Is that right?
That's correct.
And so you're saying you had not seen these slides before the marshals were trained on it?
That's
I assume you've reviewed them since then?
I've seen the slides that you referenced that Senator Britt showed to the Attorney General.
And have you discussed them with Attorney General Garland?
I have not, Senator, but I would like to make very clear the direction the Attorney General gave to the Director of the U.S. Marshal Service, who himself has indicated that he has been told repeatedly by the Attorney General that he has full authority to enforce all federal laws, including 1507, as long as he's prioritizing, and the Deputy U.S. Marshals are prioritizing, the life, the safety, the protection of the property of the justices, which is...
Under any of the other federal statutes under which they're authorized to make an arrest on the ground, have they added an additional non-statutory element to the offense, or have they required pre-clearance with the U.S. Attorney's Office prior to making a probable cause arrest?
Well, Senator, without necessarily adopting your interpretation of the slides, the Director of the Marshal Service has been very clear. He's going to regularly review that training. He's got all the authority repeatedly given to him and directed by the Attorney General to enforce federal law. His priority, however, and that of the Deputy U.S. Marshals who are providing that security and that protection, is for the property, the life, the safety of the justices and their families.
And yet, since this slide was revealed to the public, he hasn't either corrected his statement or gone back to the Marshal Service and asked that the additional non-statutory element be removed, or asked that the pre-clearance from the U.S. Attorney's Office be approved prior to the making of a probable cause arrest under Section 1507.
The statement by the Attorney General was very clear and not in need of correction. He was very clear about the direction that he is given to the Marshal Service.
He had no idea what direction had been given to the Marshal Service. No idea whatsoever. So we can say a lot of things about it. It was not clear, and he hasn't cleared it up, and it's rather inconsistent with what he told us in front of this committee.
Respectfully, Senator, the Attorney General was clear. His direction to the Marshal Service, to the Marshal Service Director, was to prioritize the life, safety, and protection of the property of the justices, to have the full authority to enforce any federal law.
With pre-clearance and with additional elements not found in the statute.
Respectfully, Senator, that was not the Attorney General's testimony. That was not his statement, his direction to the
Well, he wasn't aware
director.
of it. It couldn't be in his statement. He didn't know about it. Not when he talked to me, not when he talked to my colleague, Katie Britt. I see my time's expired. Thank you, Mr. Chairman.
Thank you, Senator Lee. Senator Blumenthal.
Thanks, Mr. Chairman. Thank
Gentleman yields back. The gentleman from Colorado is recognized. I thank the chairman. Mr. Durham, thank you for testifying today. Thank you for your service to
It's been a real pleasure.
Our country. Well, we appreciate your service to our country, to the Department of Justice. I've read your report, as I suspect most of the members of the committee have, and appreciated your work. I want to talk a bit about your interactions with Maine Justice, with the Department of Justice, and in particular with Attorney General Garland. Did Attorney General Garland permit your inquiry to proceed independently?
Yes.
Did Attorney General Garland interfere with your inquiry, your investigation in any way?
No.
Did Attorney General Garland attempt to prevent or stop you or your team from taking any investigative step that you deemed necessary?
He did not.
Did Attorney General Garland provide support to your efforts?
In terms of occasionally we would need some additional personnel. In a couple of instances, we had a person that was detailed from Maine Justice. Yes, so in that respect, yes.
Did Attorney General Garland decline to implement any of the recommendations that you've made?
I don't know that.
The letter, the report, I believe it's on page 3 of your report, you say, and I'll quote, "After the inauguration of President Biden, Attorney General Garland met with the Office of the Special Counsel. The office very much appreciates the support consistent with his testimony," referring to Attorney General Garland, "during his confirmation hearings that the Attorney General has provided to our efforts and the department's willingness to allow us to operate independently," end quote. And you stand by that, I suspect.
I do.
Correct. Sounds like the Department of Justice and the Attorney General were supportive of your efforts, did not interfere in any way with the work that you did over the course of the last several years. There are some folks here in Congress, some colleagues of mine on the other side of the aisle, who have talked about or indicated their desire to defund the Department of Justice. Do you believe the Department of Justice should be defunded?
I don't believe these discussions about defunding the police make any sense at all for the security of the nation, and I don't think defunding cornerstone law enforcement entities make a whole lot of sense. Maybe more oversight, but defunding in our cities and streets and so forth, no, that doesn't make sense to me. But I've only been at this for 40 years.
Sure. Well, and as I said, I am grateful to your service, for your service, rather, and I guess I just want to put a finer point on it because I guess I didn't hear that in your answer. You said a cornerstone of law enforcement. I take that you mean the Department of Justice. The Department of Justice obviously should not be defunded, right? You've committed your career to the Department of Justice. You were a former U.S. attorney, a former acting U.S. attorney, 35 years as an assistant U.S. attorney. You have a decorated record of service to the department. I'm hoping you're willing to say on the record clearly that you don't believe the department should be defunded.
I don't believe the Department of Justice or the FBI should be defunded. I think there ought to be some changes and the like, but defunded, no.
Thank you. And I appreciate your candor. And I agree with you. With respect to the Office of the Special Counsel, of course, you've concluded your service. As you know, there are different special counsels that are appointed from time to time. You've served in that capacity multiple times yourselves. There is discussion of defunding special counsels. Do you support more broadly the principle of defunding the Office of the Special Counsel?
Yeah, I mean, I guess I would have to know the particulars of what the discussion is, but I mean, the general notion that you would establish a special counsel office, the special counsel is doing an investigation, then you're going to defund it, would not make sense to me.
Yeah, I agree. And just to put a finer point on this, you served as special counsel for a period of years. During the course of your investigation, for the bulk of that time, Democrats were in control of the United States House of Representatives. There was no effort that I'm aware of to defund your office. And I assume that you would have construed that if someone had made an effort to defund the Office of Special Counsel, your office, as you were undertaking your investigation, as political interference, to the extent that that was being done to try to impair or impinge on your investigation. Is that an accurate statement?
Yeah, I mean, if it were our office, our team, I guess I'd have to know the basis of that to see if I thought it was, political or that,
let's say it's because people
spending too much money.
Sure. Let's say it's because people disagreed with the work that you were doing. They didn't like your investigation. They disagreed fundamentally with decisions you were making. I presume you would construe that as political interference.
Special counsel should operate independently. That's the whole purpose of special counsel. So,
I certainly agree. And again, I thank you for being here. I yield back, Mr. Chairman.
Do you believe, I'm going to shift to combating gun violence. Do you believe that a prohibited person that acquires a gun illegally and disposes it in a dumpster where a criminal or an innocent child could gain access to it should be prosecuted to the full extent of the law?
This is no longer a hypothetical question. You're referring to a specific case which is now in judicial determination before a court of law. It's not appropriate for me to comment on that case.
So, for the record, Mr. Chairman, let's understand that the same prosecuting attorney who is now the special counsel gave a sweetheart deal to that person. And yes, you are correct. We're referring to the president's son. He got a sweetheart deal, and the judge was smart enough to smell a rat when she saw it, and she said, you guys go back to the drawing board. That same special counsel is in charge of this investigation. Isn't that correct, Mr. Chairman? Absolutely. I want to close real quickly with this. There was a World Naked Bike Ride in Madison, Wisconsin, just a couple months ago, and I sent you a letter 2 months ago asking if you had a problem with that because it exposed a 10-year-old girl by the race organizer, the bike organizers, to pedaling around Madison, Wisconsin naked. Do you think that's a problem? And why did you not answer our letter from 2 months ago?
I'm sorry, I'll have to ask the Office of Legislative Affairs to get back to you about this.
Does it typically take 2 months to be able to answer questions like this?
It sounds like you're asking about a question about state and local law enforcement. We get hundreds and hundreds and hundreds of letters. I'll ask the Office of Legislative Affairs where that letter is.
State and local law enforcement would not act. We were hoping you would. It's obvious you're not. I yield.
Gentleman yields back. With that, I would yield to the gentleman from New York, the ranking member, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, at the outset, let me make 2 comments. One, just about every assertion you made in your opening statement has been completely refuted by witnesses who have testified before this committee. 2, far from being favored, many commentators have noted that people accused of simple gun possession while under the influence of a drug, when that gun was not used in the commission of a crime, are rarely, if ever, prosecuted the way Hunter Biden is being prosecuted. Mr. Chairman, one of this committee's most important duties is conducting oversight of the Department of Justice. We are called upon to ensure that the DOJ uses the enormous amount of power it is granted in a fair, just manner that respects the civil and human rights of all Americans. The Attorney General of the United States oversees issues that affect the lives of each and every American. Violent crime, drug trafficking, attacks on our civil rights, threats to our national security, and environmental crimes all fall under his purview. That is why we regularly request that he or she appear before this committee to speak about the work the department is doing for the welfare of the country. This is how we ensure that the department stays accountable to the American people. But if it were up to the Republicans, Americans would hear nothing about any of these substantive issues today. They would hear nothing about the rise in domestic terrorism and what the Justice Department is doing about it. They would hear nothing about what the department is doing to stop hate crimes and prevent gun violence. They would hear nothing about how the department is disrupting efforts by Russia, China, and others to interfere in our elections. Extreme MAGA Republicans have poisoned our vital oversight work. They've ignored our legitimate oversight responsibilities and used their power to stage one political stunt after another. They have wasted countless taxpayer dollars on baseless investigations into President Biden and his family, desperate to find evidence for an absurd impeachment and desperate to distract from the mounting legal peril facing Donald Trump. They have fought tirelessly to stop efforts to fight malign foreign actors trying to influence and manipulate Americans through social media. They have unconstitutionally interfered in criminal litigation and attempted to bully state and local law enforcement officers. They have publicized the names of witnesses who did not further their political goals, leading to threats of death and physical violence against those witnesses and their families. They have cost any number of private institutions and companies millions of dollars in legal fees as they struggle to respond to ridiculous and overbroad requests for information and transcribed interviews. They have issued subpoenas for show without making meaningful attempts to get the information they seek by consent. They have levied low, baseless personal attacks on any prosecutor to bring charges against Donald Trump or January 6th rioters. They have attempted to discredit investigators who are not hard enough on Donald Trump's political opponents. They have supported those involved in the deadly attack on our Capitol on January 6th in an attempt to overthrow a lawful election. They have justified conduct that we all know to be wildly illegal, like the theft of classified materials and incitement to violence. And through it all, rather than try to unite the country or solve the problems that affect us all, they have sought to exploit our divisions for cynical, personal political gain. That is their goal, division. They want to divide this country and make our government appear like it's broken, because that is when their broken political party thrives. So today, I implore the public to see through the sham. I have no doubt that you will hear a deluge of conspiracy theories and baseless accusations. They will quote freely from so-called whistleblowers who have been broadly discredited or contradicted. They will viciously attack federal law enforcement. They will tell you that all 91 criminal charges against Donald Trump are part of a conspiracy, despite overwhelming evidence of each of Donald Trump's crimes. And they will attack Special Counsel Weiss, who was appointed, let us not forget, by Donald Trump, for not being hard enough on Hunter Biden. Republicans will continue doing what they've done for years, discrediting anyone who does not serve their political goals at any cost. And the shame of it is that in this hearing room, like on the House floor, where we are barreling towards a government shutdown while my Republican colleagues call each other names, we could be working together to put people over politics and to solve any number of problems affecting the American people. More than 30,000 Americans have died from gun violence so far this year alone. Guns have become the leading cause of death for children aged 1 to 17, surpassing car accidents. Domestic violent extremism and white nationalism are on the rise. We are seeing active clubs and other white supremacist groups pop up around the country. Anti-Semitism is at an all-time high. Malign foreign actors like Russia, China, Iran, and North Korea are attempting to influence our elections. Political rhetoric is causing threats against law enforcement officials to skyrocket. Our immigration court system is in desperate need of reform. Our election workers receive death threats from conspiracy theory-driven extremists. Fentanyl is filling our streets and poisoning our children at historic rates. This list goes on, and we, the people in this room, are in a position to do something about it. In fact, it is our duty to do something about it, consistent with the oath we took when we were sworn in as members of Congress. We could work with the Department of Justice and Attorney General Garland to address any number of real substantive problems facing the American people. Instead, House Republicans will use their time today to talk about long discredited conspiracy theories and Hunter Biden's laptop. They will do it because they care more about Donald Trump than they do about their own constituents. I hope my colleagues will see reason and at least attempt to work with the Attorney General in good faith. Sadly, on the other side of the aisle, reason and good faith seem to be in short supply. In any event, Mr. Attorney General, I thank you for your testimony and thank you in advance for your patience.
The gentleman from Oregon is recognized for 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Attorney General, for being here today. I would like to go back briefly to your remarks regarding the